Now.
Okay, so I'm going to reintroduce myself. My name is Parisa. I am the Program Manager for Legal Education and Outreach at AsylumWorks. I work in the social services team. And tonight I wanted to have a community conversation about the AsylumWorks versus Mayorkas case that we won in the district court. And then there's another temporary final rule that's kind of related to asylum seekers, and it's about the automatic extensions for the EADs. I know there's been a long backlog, but before I start, I just wanted to make sure that everybody's aware that there won't be any questions until the end of the session. And also all of this information is located on the USCIS website. What I'm conveying here is in no way legal advice. Okay. So to begin, the reason why this session took a little bit longer than anticipated is because AsylumWorks actually won this case in February of 2022. But the government had until April 9th of 2022 to appeal this case. So therefore, USCIS could not publish this information. After April 9th, they published the information. This information is not located on the instructions. It's located on their website. They have not actually redone their instructions yet for the form, but eventually, when the form expires, which it's set to expire on July 31st, most likely they'll republish the instructions with these new instructions that I'm going to go over. And I actually did like a bullet point of these instructions on this flyer. If you did not get a copy of this flyer, just reach out to me or Cynthia after this session and we can provide it to you. To begin, so I wanted to say that one of the greatest things that happened with this case is that it basically took the really stringent rules for EADs for asylum seekers, and it vacated all those rules. That means it removed all those rules, and they said you're going to go back to the pre-2020 rules with these cases. So what does that mean for all of you? So first and foremost, if you're renewing your employment authorization document, if you're applying for the first time, or if you're applying for asylum, you're still going to use the old form. So please continue to use the current form I-765, which is for the employment authorization document, and the form I-589 for asylum. It's dated August 25th, 2020. We know the form is outdated, but eventually they're going to republish it. They're just saying, please use it for the time until we have time to republish it with the instructions. That's first and foremost. That's the first box you're going to see. As many of you know, prior to AsylumWorks winning this case, there was another case that allowed you to kind of get ahead in line, and that was the Casa de Maryland versus Mayorkas case. That was basically what's called a preliminary injunction. A preliminary injunction is a court order, and it's done before something goes into effect. And it forbids the government from doing an act when a dispute is in the court. So what that dispute did, it said that if you're a member of Casa de Maryland, or if you're a member of the Asylum Seekers Advocacy Project, you could include membership in those organizations, and then you would be able to apply after 150 days, and it would be litigated within 30 days. So before, you had to submit that membership in order to apply for the old rules. You don't have to do that anymore, but USCIS stated if you want to continue to submit those memberships with your EAD applications, you can do so. However, in this decision in AsylumWorks versus Mayorkas means that you do not have to apply for memberships in those particular groups. And all of the rules that were predating 2020 rules will apply to your case. And so what are those rules? Do you want to know? So first and foremost, if you're a first-time asylum seeker, you can apply for your employment authorization document 150 days after you file your asylum application, instead of having to wait the 365 days. I know for a lot of people, it was really hard waiting an entire year to apply for their employment authorization document. I don't know many people that cannot not work in the United States for a year and support themselves. So this kind of helps in that process. However, with that, even if you apply within 150 days, they're not going to make a decision on your case until the 180th day since you applied for your asylum application. So about 6 months after, you should receive a decision about your EAD, and most likely it's going to be granted. Another thing that this case did is that you no longer have to pay a biometrics fee. A biometrics fee is basically the fee you pay to get your fingerprints and your pictures taken. They are no longer collecting biometrics fees for EADs based on asylum seeking applicants, and you don't have to go to a biometrics appointment for your EAD. However, you will be asked to go to a biometrics appointment for your underlying asylum application. So when you file your asylum application, you'll get an application support center appointment letter that says you have to show up to your biometrics appointment at this day and this time and get your fingerprints taken. Once they do that, you don't have to go again for your employment authorization document, and you don't have to include that $85 for the biometrics fee. For first-time asylum applicants, the application fee is always $0. And then for renewals, it's $410. So you don't have to tack on that additional $85 to the $410. And if you submit the biometrics fee, most likely you're going to just send it back and tell you to reduce that fee back to the original price and then resubmit the application. Another thing they advised after this decision is to please continue to respond to what they call a request for evidence or a notice of intent to deny. So if you submit any type of benefit before USCIS, whether it's an employment authorization document, it's an asylum application, it's a regular family-based petition, once in a while, if you don't submit enough evidence up front, they send you a letter. Sometimes it comes in a blue paper or sometimes a yellow paper, and it's a request for evidence. That means they're trying to make a decision on your case, but they need more evidence to do so. And on that letter, it'll say exactly what they require, and they'll give you a timeline of when to submit it. Sometimes they'll just send a request for evidence. For example, let's say your medical exam expired when you were doing an adjustment of status. That happens if it's been in the pipeline for a long time, and after 2 years, they need a new medical exam. So they'll send what's called the request for evidence or an RFE, and they'll say, go get a new medical exam done and send it back. That would be one reason. There could be a multitude of reasons for these. There's also a notice of intent to deny. That might be like there's a benefit that you're seeking, but USCIS is like, I don't think you're eligible, so we intend to deny it unless you provide this other additional evidence. So please, if you get these letters from USCIS, continue to address those letters within the time they give you. Because if you do not address those letters within the time they give you, or try to get an extension on those letters, they will deny your entire benefit. And we would hate for that to happen because you missed a letter in the mail. And again, if one of those letters comes for you, I would probably consult your immigration attorney, because there might be asking for something that you don't have an idea about what the document is about, but your immigration attorney does. The next thing that the case changed was that you don't need to answer questions on the form I-765 about whether you have lawfully entered the United States through a port of entry. Now, the 2020 rules that were enacted under the previous DHS secretary stated that if you came into the United States and you were not inspected by Customs and Border Patrol, for example, you didn't go present yourself in front of them and say you want to apply for asylum. I think a lot of people were hesitant to do that because they were being put in detention and they didn't want to be put in detention. So as kind of like a bar on that, they decided that anybody who did that was not eligible to apply for an employment authorization document. You could still apply for asylum, but because asylum is a human right, the only way that they could deter people from doing that is by kind of making EAD and a collateral to applying for asylum if you came without being inspected. Now they cannot deny you if you came in without inspection at the southern border. Asylum, again, is a human right, and you shouldn't be denied an EAD just because you came in and were not inspected by CBP. You can still apply for asylum and your EAD. Therefore, on the form, it says you do not need to answer question 30B through G on I-765. USCIS no longer considers responses to these questions, which asks about why you entered the United States, whether you were inspected, admitted, or paroled, and when they adjudicate your EAD based on category C8. Category C8, I might mention it several times, that's the category for pending asylum seekers. If your asylum is granted, your category changes to A5 until you get your green card. So if you ever hear me refer to category C8, that's for pending asylum seekers on the employment authorization document. Another beautiful thing that AsylumWorks versus Mayorkas changed was that your employment authorization document can't be denied if you didn't meet the 1-year deadline to apply for asylum. Many of you have already applied for asylum, so you're well aware that when you apply for asylum, the general rule is you have to apply a year within entry, whether you enter through a visa, through the southern border, with or without inspection. Once you have entered, the clock ticks 1 year down, and that's the latest you should be able to apply for asylum. However, there's always exceptions to that. You can get around the 1 year deadline, and I'm not going to go into that in detail because I would hate, that's not a best practice to do that. But the good thing is that let's say there was an emergency situation, you couldn't file it within that year. They're no longer able to deny you because you weren't able to file it within that year. You may be granted employment authorization based on your pending asylum application, even if you did not file within a year after you entered the United States. Another thing that changed under these new rules is the eligibility criteria related to certain criminal acts and convictions are no longer applicable. So the old asylum EAD rule prevented asylum seekers who were convicted of certain crimes, offenses, committed of particularly serious crimes, or committed serious non-political crimes from receiving an employment authorization. They expanded the category. Now they're like, you cannot deny people for all of these types of crimes from being able to work. However, now, if you have been convicted of an aggravated felony, it still makes you ineligible for the employment authorization card. And an aggravated felony generally refers to a very serious felony, and you have to be convicted of it to be ineligible. So that list includes, but it's not limited to, like convictions of murder, rape, trafficking of drugs and firearms, and etc. It's a long list, laundry list of what an aggravated felony is, but just like very serious crimes. Convictions for these types of crimes may still prohibit an applicant from receiving their EADs, but other like non-serious crimes won't prohibit you from becoming eligible. Another great thing is, there's time periods where, like, let's say you went to the asylum office, asylum officer wasn't really sure if they want to grant your asylum, and then, you're afraid your EAD will be terminated within 60 days. So if USCIS denies your asylum application, your EAD will not automatically terminate on the date they deny your application. If you're in a lawful immigration status or have parole, and an asylum officer denies your asylum application, which is something that is happening at the southern border. Most cases here, they don't have the jurisdiction to deny an application. They can kind of just put it into the court system. So your EAD issued based on your asylum application will terminate after 60 days after the denial decision or the expiration date on your EAD, whichever is later. If you're not in a lawful immigration status or do not have parole, and an asylum officer refers you to your asylum applications to an immigration judge, which is most of your cases, for further consideration, your EAD remains valid through the date of the expiration unless renewed. So let's say you go to the asylum office, they're like, we're not sure, we're going to refer it to the court. It doesn't automatically terminate your EAD. You can continue to work on your EAD, and then it's going to go before the immigration court. If the immigration judge denies your asylum application, your employment authorization will terminate on the expiration date printed on your EAD, unless you appeal the immigration court's decision to the next high court, which is the Board of Immigration Appeals. Or after the BIA review, after the Board of Immigration Appeals or after the BIA review, you appeal the BIA's decision to the federal court. You may file to renew your employment authorization if you timely appealed to a US Court of Appeals, and that decision remains pending. So there was this little time slot. Let's say you went to immigration court. The immigration judge is like, I grant it. But then the DHS attorney is like, I'm going to appeal it. And then you go before the BIA. And the BIA is like, well, I'm going to reverse the immigration court's decision. And on that time, you can still work on your EAD. Now, let's say before you wanted to, the Board of Immigration Appeals is like, well, I want to deny this case. This should not have been granted. And you're like, you know what? I'm going to take it to the next highest court, which is a federal court. And that interim between the Board of Immigration Appeals and the federal court, you couldn't work on your EAD. Now they say if you may file a renewal of your employment authorization card if you made a timely appeal to the US Court of Appeals, and that decision remains pending. So if you're still pending before a federal court, you're allowed to work on your EAD and you don't have to stop working. So that was another thing that it did, because if you're waiting around for the federal court, who knows how long the docket will take, how long they might wait to hear your case. And so you'll probably need to work in that interim and make an income. Another lovely thing that happened, which is what most people are affected by in this category, is that the 30-day processing rules, under the previous rules, there was an indefinite timeline rule that they just came up with. And they're like, if you submit your application, we can take as long as we want. And the district court said, actually, we side with AsylumWorks. You can't take as long as you want. People need to get their EADs timely. So now they've switched it back to the original 30-day processing requirement, and it's been reinstated for initial employment authorization requests. So that means the first time authorization requests, not renewals. Renewals can still take a certain amount of time, but that's why they gave the automatic extension for the ones that you're renewing. For first-time asylum-seeking applicants for employment authorization documents, USCIS is supposed to technically process your EAD within 30 days of when they receive the application. And if they don't process it within 30 days, I would encourage you guys to give them a call or write them an email, because sometimes they overlook things without realizing it. And you'll have the right to that 30-day processing. And again, let me just reiterate, that's for first-time people who are applying for their employment authorization document. Another great change is that employment authorization decisions are no longer discretionary for category C8. Again, category C8 is pending asylum seekers. This regulation is now in effect, and it removes the officer's ability to deny your employment authorization document where the individual meets all of the eligible criteria. Before, they could still kind of weigh it and be like, due to security concerns or whatever we want to say, as a matter of discretion, we're going to deny your EAD. Now they don't have that discretion anymore. They have to grant it if you meet all of the eligibility requirements. Another rule is that USCIS must deem complete certain asylum applications. The rule is that allowed USCIS to reject asylum applications that were not properly filed more than 30 days after USCIS received it is no longer in effect. Your guys aren't really going to see the effects of this. It's just something, it's a guideline that USCIS officers are going to follow. So there's certain applications where previously they used to just reject because they were like, oh, they're not properly filed. And now they're just like, it's no longer in effect, and you can deem them as complete applications for the EAD purposes. This is all to move up the timeline. Another great change is that asylum officers will consider all evidence you submit before or during your interview. Asylum officers will consider all evidence you submit. An asylum officer may postpone your scheduled asylum interview if they are not able to review the evidence submission before the interview because you did not submit it in advance of the interview. Also, an asylum officer may decide to grant you an extension of a time to submit additional evidence after your interview. That's where you would get a request for evidence. If USCIS postpones your asylum interview for review of evidence due to a late submission, or if USCIS gives you an extension of time to submit additional evidence for your interview, the delay and the adjudication of your asylum application may stop your 180-day EAD clock, and it may affect your eligibility for employment authorization. But these rules are all case by case. So if you're planning on asking me a question about this bar, you should probably ask your attorney, because I can't give you case specific timelines. It's between you and your attorney when you all filed the EAD and if there was any other issues about additional evidence that needed to be provided. So that's all AsylumWorks versus Mayorkas. I've kind of gone into a little bit of detail. If you have any questions, just jot them down right now, and then I'm happy to answer them after I go over the temporary final rule for the 540-day automatic extension on EADs. That's the last thing I wanted to cover. It's not on the AsylumWorks versus Mayorkas case, but it's kind of like this new rule that they granted because of the long lines and the people having lapse in employment authorization. So effective on May 4th, 2022, USCIS increased the automatic extension period for employment authorization documents. And it's available for certain EAD renewal applicants. Asylum seekers are included in that, and it's up to 540 days. So I'm going to go into that in a little bit of detail. So the automatic extension time is counted from the expiration of the employment authorization and or the EAD card. So look at that, and it's like you're going to count 540 days from that. The temporary increase is available to eligible renewal applicants with pending applications if they filed their EAD application either before May 4th, 2022, and your 180-day automatic extension has expired. So this should be able to reinstate it. If you filed before May 4th, 2022, and your 180-day extension has not yet expired, it just increases it by 360 additional days. And if you filed it between May 4th, 2022, and then October 26, 2023, you'll just get a receipt that says that this is valid for 540 days after it expires. So that extension should still be good. Many of you probably are like, well, how do I know? If you filed an EAD and you got a receipt that said you qualify for the 180-day extension, then you qualify for this additional 360-day extension. If you file an EAD after May 4th, 2022, you're not going to get a I-797 receipt that says 180-day automatic extension. It's going to say 540-day automatic extension because the rule went into effect on May 4th and after. If you're not sure, or you don't have your receipt, or you don't remember, you can always call USCIS and confirm that you're eligible for the 180-day extension because you filed it timely. And then if you were eligible for the 180-day extension, then you automatically are eligible to extend it for another 360 days. This is the current administration's way of ensuring that there isn't gaps in employment when they're having this time that they need to catch up on processing the EADs. It's been an issue in the last 4 or 5 months. There's been some gaps here and there, even with the 180-day extension, and they don't want anybody to lose their employment as a result of USCIS's pipeline. I think that about covers most of it. If you all have any questions, I think we can stop the recorded session now and then get to the questions.